Well, thank you for joining me today. We have an insightful webinar, I hope, tailored specifically for real estate professionals. We are going to dive into some real world cases, examples of violations that have come under investigation, and hopefully that will provide some valuable lessons on what to watch out for and how to stay compliant with law and rule. I'll also give a brief overview of the regulatory process. Just to have some insight into how our agency ensures fairness and transparency in our processes, as well as consumer protection. So whether you're a seasoned agent or new to the industry, this is hopefully going to equip you with some practical tips and insights. But should we maybe start first with some introductions? Normally I give presentations with a peer or the commissioner, but it's just me today. I'm excited to be here with you all. My name's Ellie Katara, and I've been with the real estate agency here in Oregon since 2021. After 12 years with the Oregon Department of Human Services and then the Office of Child Care. So I've been a manager with the state of Oregon for more than 10 years, always leading teams of people that are tasked with ensuring safety and consumer protection. Um, by the time you're done with this, we hope that you'll have a solid grasp on how the agency handles investigations from start to finish. We'll talk about the kinds of violations that typically trigger a case, and more importantly, what you can do to stay on the right side of compliance. So at the Oregon Real Estate Agency, we're organized into several divisions. If you're a licensee, that means that you've engaged with the licensing division, which handles applications and renewals for the real estate licenses. But my division is different and separate. We're the regulation division. Our team is responsible for investigating complaints. These come from the public, you all, licensees, and other government agencies. And we even have a handful of cases every year that are actually initiated by the agency itself. Typically, those are a result of either information we learn through the course of an investigation or through a compliance audit that is in the property management world. We look into the actions of real estate brokers, property managers, escrow agents, and anyone else involved in the real estate activity that falls under our jurisdiction. And our investigators serve as neutral fact finders, gather. So let's kind of get into it. Today, our complaints are submitted through our e-licensing system. Once a complaint comes in, our staff review both the complaint itself and any supporting document or documents provided by the complainant. If a complaint is filed against you, you'll have the opportunity before we decide whether or not to open investigation to share your side of the story and offer anything in response. That's why it's so important for you to pay attention to getting an email from our agency because you'll be sent a copy of the complaint. We really, really value transparency in this process, and we want to make sure that you have the opportunity to share any information or documents that support your side of the situation or clarify the situation. Not all agencies do that. Sometimes a determination about whether or not to investigate is made just based on who calls us and what they say. But we're an agency that really values your time, and you have the opportunity to respond, which may prevent you from having an investigation. If you don't respond, though, and the allegation is within our jurisdiction, there's a pretty strong chance we'll move forward with a formal investigation if what's alleged is a violation. So please, please respond. It's very important, but it also saves you a lot of time in the future. Our team will determine if the case will be opened as an investigation or closed because the agency doesn't have jurisdiction. As I mentioned, we always need to know whether or not it's our business or someone else's or not a violation at all and just somebody who's unhappy. So first and foremost, that's what we're going to do. But I also want you to understand that we sometimes issue an educational letter of advice just immediately out of a complaint. I'll give you an example. So if somebody calls and makes a complaint about your advertising and they provide information that you have actually violated law or rule related to advertising, the agency will go ahead and issue an educational letter of advice in hopes that you will be able to take corrective action. But we don't feel like a mistake in advertising or an error in advertising is enough to open a full investigation. So there are times where a complaint could be filed against you and you will just get an educational letter of advice. This can occur at any point. We'll cover more details on how an investigation is done in the next section, but if an investigation is assigned, um, upon the completion of the investigation, the agency will take one of four steps. And then, like I mentioned, some of our investigations are just closed, either because you've provided us information that lets us know that the information provided was not factual or complete, or that there were mitigating circumstances. So finally, if an investigation is opened, there are several outcomes. One of those is no action is taken. We look into it and no violation occurred. We can also send an educational letter of advice at this time. Maybe there was a minor violation, but the impact was low and there was no harm. And so we're going to take the opportunity to support the industry in raising that level, and go with an educational letter of advice. Another thing that can happen is an administrative action. So when that happens, the commissioner has determined that the conduct that's occurred goes beyond what's reasonable and does violate law or rule. And finally, civil penalties. These can occur for unlicensed activity or in property management for failure to produce records, those types of things. One note here, the real estate agency has sent educational letters of advice recently on cases that concern seller impersonation fraud. When we send an educational letter of advice, those do not go in the ORNJ, so you won't see the ELOAs, but complainants in those situations are made aware of that outcome. And this trend of seller impersonation fraud, both with vacant lots and actually often with sellers indicating they're not available to meet in person, is something that the agency is looking at issuing reprimands for in the future, because we've now published 2 articles about it in the ORNJ, and I think the industry is aware that this is occurring. And so there are very clear actions to take to verify seller information that could prevent the harm that's occurring in these cases. I'm going to go over just a little bit more about each of those and some outcomes, and then we'll dive into some cases because I know that's what you're all interested in learning about anyway. Um, at the conclusion of investigation, the facts of the case will result in these actions that I described that were also listed on the last page. But I just want to point out, often our investigations do not result in any action at all. And I think people get very worried when they're part of an investigation, and I certainly understand that, and I would if I was in that position as well. But the majority of our cases are actually closed before they even get to investigation. Just because a complaint is filed against you does not mean it'll become an investigation. And then many of them are closed after investigation with no action. If our investigation results in the identification of a minor violation, as I mentioned, a letter will be sent. This is not disciplinary. It will not appear in our disciplinary records. And as I mentioned, it won't be published. The purpose of the letter is just education, and it'll be expunged from the agency's records in 6 years from the date of issuance. The reason we keep them that long, though, is we do have rules around progressive discipline. And if we've attempted to educate and the issue continues, then we would look at something more serious, like in an administrative action. So when an investigation results in a violation that's warranting administrative action, the agency can pursue reprimand, suspension, or revocation. And this level of action is determined by the real estate agency's commissioner, excuse me. And like I mentioned, civil penalties most often just apply to unlicensed activity, escrow violations, failure to respond to agency requests. that kind of thing. But I will say we have had unlicensed activity occur when licensees fail to renew their license. So just because you are licensed doesn't mean that you would not receive a civil penalty. Unfortunately, more than I thought, civil penalties have happened with those who were licensed for many years and missed their renewal date. And we try to be understanding, but we do send multiple email reminders, and there are systems in place so that those don't get dropped. Okay. Just to sort of underline the point that just because you have an investigation or you're part of an investigation, that does not mean that you're going to be prevented from participating in your profession. Only 37% of cases that go to investigation result in administrative action. I think it's important to note that this includes property managers. So this number is not reflective of the number of brokers or principal brokers that are receiving administrative action. 37% of cases total, including escrow and property management. And 58% of that 37% are reprimands. So that means that most of them, the folks that experience an investigation that does result in administrative action, well, nobody wants a reprimand on their record. It doesn't interrupt your ability to continue to do real estate activity the way a suspension or a revocation would. Finally, sort of the last piece around what we do and how we do it, what to expect during an investigation. So whether you're involved in an investigation as a complainant or a respondent, because a lot of our complainants are actually from the industry and helping keep the industry in ethical and maintain integrity kind of way, there are a few things that you can kind of expect across the board. First is that we're committed to clear and timely communication throughout the process. So you'll have an opportunity to share relevant information. That could be documents, emails, other names of people who are aware of the situation, or anything else that helps us understand the facts and circumstance. Then once a case is assigned, the investigator conducts a review of that case and all the records within a week, and they'll develop a strategy, sort of identify key documents, and determine who needs to be interviewed. From there, they'll gather any missing information. So if they are missing a document that they think would help determine what occurred, they may ask you for that. It could be a listing agreement, but it could also be text messages between you and a client. And then the report is reviewed by what we refer to as a senior case analyst or a lead worker to ensure that it's complete and unbiased. So an experienced worker who has a different title, different position, different responsibilities, who's never talked to anyone in the case, most likely. And they're going to review the evidence that's been provided as well as the report to determine what needs to happen and ensure it's complete and unbiased. So at that point, after that review, either the case is closed or it's referred to the commissioner for possible administrative action. The one question I get a lot is how long will it take? Our investigators get that question a lot too. If you're part of an investigation, how long is that going to take? We complete over 80% of our investigations within 150 days. That's start to finish. So it means from the day we receive the complaint to your opportunity to provide additional information, to investigator being assigned and doing their responsibility, and a final review. 80% of our cases are completed within 150 days. That sounds like a long time, but some cases, this is an average number, right? So some cases take much longer, especially, as I mentioned, property management cases with a large volume of bank records, but many of our cases are resolved much more quickly. So our goal is to be thorough and efficient and get it right. So we definitely don't want to rush, but we do understand that going through an investigation process can be stressful. So we do it as quickly as we can. I'm going to pause here before I launch into the case examples. I really wanted to give you as much time with the cases as possible to be able to also ask questions and that kind of thing and interact with the next piece of information. But before I move on, are there any questions about how the agency does their work so far?
There is one in chat. I apologize, I may have missed if you had already answered it. It's about if we file a complaint and it is investigated and the party is found to have done wrongdoings, what does the person filing the complaint ever get told what the penalty slash reprimand was? Are they kept?
Yeah, yes, that's a great question. So at the end of any case, the complainant and the respondent are communicated with the results. So an email is sent by the lead worker indicating that either that includes what the result is, or if there's administrative action, you will be notified of that as well. So if there's a reprimand or anything.
Okay.
Oh, it's Tang at PMAR. Can you just briefly give a reference to where we are today with timing in the agency and the cases, how that's being responded to versus the past? Just no pointing fingers or anything, but just how efficient has the agency become in this arena?
Yeah, thank you for your question. So when I joined the agency, I think our average number of days in investigation, and this is a ballpark, but it was between 160 and 170 days to complete the investigation process. We have probably reduced that by half for our role. So when I say 150 days, like I mentioned, that includes the complaint intake process and a review on the other end. But the investigation itself, from the time an investigator receives the file to when they are done with their portion of the job, we're often averaging about 70 days to 80.
Thank you.
Yeah. We also, I don't want to get into so much minutia that it's unimportant to folks, but we do a good job of identifying at the beginning of a case whether or not we believe it's a long-term pursuit, right? And as I mentioned, property management cases, sometimes we're going to have to subpoena bank records or do something that we know is going to add a lot of time to our investigation. A lot of our real estate cases that are truly about a transaction, the facts are either provided or they're not in those documents or in the communication, which is why every time the commissioner has an opportunity with an audience to remind folks, document, document, document. If you don't document, it didn't happen. So our cases are pretty quick. Sometimes as short as 13 or 14 days. If somebody alleges something and you provide documentation that it's not founded, not true. But a lot of times when folks can do that, even in the beginning, when we provide a copy of the complaint and say, this is what somebody has alleged against you, it never even becomes an investigation, never comes to my division because they can close it on that front end at the complaint level. Are there more questions?
There are some in chat. Mark Wheeler asks if an ethics complaint, which is our process to the association, is received and the issue is also turned into the real estate agency, do you all currently recommend the associations hold off on their process or until your investigation is complete? In the past, OREA has said don't wait because you are all backed up. At the same time, the association tended to wait anyway. What do you recommend?
Yeah, thanks for that question. I don't recommend anything, which sounds very, very lawyer kind of answer, and I don't mean it that way. But from our perspective, we have a role and we have jurisdiction, and the scope of what we do is very clearly outlined. And what you all determine or don't determine in an ethics issue will not tell me whether or not law or rule was violated based on our own criteria. So if there were folks in the past who worked for the real estate agency who felt that one process needed to occur before the other, that's no longer present in the agency as of at least 2021 when I started, and I imagine at least since this commissioner, Steve Strode. I do understand there are times where some processes need to play out. We have had situations where somebody has reported an adverse action and there's a pending criminal charge and we may need to delay certain action because of that, but not in an ethics situation since we don't regulate the same things as the association.
All right, another one is, how many complaints do you receive each year?
That's a great question. If you don't mind, I'm going to jot that down and I can send it to someone, but it's not my division. So the complaints actually go through the licensing division, a staff member or two in the licensing division. And we do that intentionally. We want to make sure that complaints are processed without regard for anything that could be tempted to like, oh, the workload's too big, let's close a few out. You know, we don't operate that way. Not that anyone else does that I know of, but we want to make sure that the processes are siloed enough to prevent from any bias, internal or otherwise, about whether or not the case should be open. So it's actually processed by another division.
And then the last one, Karen Hughes asks, is there any consequence for someone filing false complaints?
Unfortunately, I get this question a lot, and we allow, you know, we're a public service agency, and we allow complaints to be submitted. We have had in the past someone try to take civil action against repeated false claims, but knock on wood, we haven't had many of those, and lots of times when there's a pattern of that without the person's ability to provide enough documentation, we may accept their complaint. We may continue to ask you for your response, but if there isn't anything substantiated, we'll close it without it going to investigation. We have had times where we've closed a complaint 2 or 3 times, and then someone gives us information that sort of tips the scale, the burden of proof. And so we'll open an investigation, but not as like a reward for complaining many times, more like you gave us a piece of information that we didn't have before. And sometimes that's the best way to satisfy a person who believes they've been wronged, is to complete the investigation and be able to show that the agency did their job to look into any potential harm in consumer protection. But many of those cases do actually result in us determining that no violation actually occurred.
And Michael Redmond has his hand up.
Yeah.
I have heard it as an ongoing concern in the smaller communities that some realtors hesitate to bring complaints because they worry about retaliation from larger brokerages or more powerful agents. Are complaints able to be anonymous for the entire process all the way through, or is there a stage at which the complainant would need to be identified to the person who is under investigation?
Thank you for that question. It's a really important one. Because part of our value system includes transparency, we don't we're not really even permitted, based on the way that public records law works, to hide information. You know, there are agencies, I used to work for child welfare, for example, where reporting parties are confidential, or some places where they're confidential unless the records are asked for. We really believe in a high level of transparency, because it also better allows someone to respond to a complaint if they know where it came from. Does that mean that everybody always feels comfortable filing a complaint, even if they do have a valid concern? No, of course not. And I do understand that small town dynamic in particular can be challenging, but for anyone who's received feedback or criticism, but not told where it came from, that can also be one of the most frustrating experiences to go through. So as an agency with a high value on transparency, both transparency about our processes and amongst the community of licensees, and not all complainants are licensees, but we don't, our process requires information be given online to even file a complaint. Okay, does that cover it?
Yep, there is one from Mark Wheeler here. I'm not sure if it's an actual question or just comments about, maybe you can read that and respond if you'd like. But
Okay. When I'm sharing screen, it doesn't actually allow me to look at the chat, I realize. So maybe I'll look at the end after we get to questions and we'll move on to the
Kelly, can I jump in and
yeah,
clarify?
yeah,
Thank
that'd be
you.
great. Thank you.
Thank you. So it sort of tags on to what Michael Redmond just pointed out. I once just asked OREA about someone's business practice. They, without asking me any follow-up, opened a complaint naming me as a complainant. I was not complaining. I was asking if something was licensed activity. I would just ask you all to be a little more careful before just opening a complaint and saying, hey, this person's telling on you, kind of thing.
Thank you, Mark. Okay, so our first case, the nature of this case is around a criminal conviction, fraud and dishonest conduct. So in this case, the licensee was charged with theft in conjunction with his fiduciary duties in another job. This was not in the course of a real estate transaction. The agency received this information from the licensee themselves. They self-reported. The pending charges at the time he self-reported were classified as felonies. After investigation, the agency sent the licensee what's called a settlement letter. And essentially, we indicated the serious nature of these criminal charges were not yet resolved, but there was enough evidence and indication that there was a misappropriation of funds that we felt there was enough to revoke the license. The licensee asked for a settlement conference, which is always an option for anyone going through this. It's an informal live meeting where you, after the investigation, and you've received a copy of the investigative report, you can provide any information that you feel like wasn't captured or maybe mitigating information, like this is true, but you're missing this detail, which provides clarification or background. So he took the opportunity to bring that mitigating information forward to the settlement conference, including that between when the investigation was opened and when the settlement conference happened, there had actually been a reduction in the charges to misdemeanors and several of the charges dropped altogether. So let's see. I think in this case, eventually the agency sort of discussed with the licensee, what do you have in mind? We're a consumer protection agency. And his argument was really that as a real estate broker, he doesn't very often and not in large amounts deal with money. Like a property manager might, that the escrow process provides a lot of protections for that. And there was a lot of back and forth and a lot of discussion about what made the most sense. So we ended up entering into a settlement agreement where this licensee, who was a principal broker, agreed to have their license surrendered as a principal broker and enter into a limited license as a broker. And that reduction from principal broker to broker allowed for more protections around the financial aspects that would be vulnerable. And that one of the stipulated terms was that he would have the right to request a principal broker's license again after 5 years with restriction on property management activity. Now, I want to make sure it's clear that he has the right to request that. He does not have the right to automatically receive a principal broker's license just because he can request it. The settlement was more creative and more complex than a straightforward reprimand, suspension, or revocation. We take the consumer protection portion of our job very seriously, but there are a lot of protections provided by the escrow process and the business model that occurs between a broker and a principal broker. And so I think it's important that we understand what the real risks are and create guardrails when we can. When people can do this job safely, we want them to be able to do that, as long as we can also protect those who might be in their clientele. So one key takeaway from this case, I think it's important that you understand when you act in the fiduciary trust of others, that your actions can impact your real estate license, even if the conduct was not real estate professional activity. So in this case, the misappropriation of funds, which he did pay back, that was another argument of, well, I did use this money that was from an account with others' funds in it, but I reimbursed it. So just understand that even actions outside of real estate activity can impact your ability to do this work as a licensee. Okay, next case. In this case, a licensed broker decided to solicit money from others for real estate investments with the promise that he would pay a monthly return of 10 to 20% of the investment amount. Then over the next year and a half, the licensee met with clients and potential investors at his real estate office in Salem to discuss this investment opportunity. He provided prospective investors with his real estate business card. He explained that he would accept whatever amount the investor was willing to invest and that he would pay a monthly return. In these agreements, it listed 10, 15, or sometimes even 20% on the investment amount. He said they could withdraw their money at any time. And then if the monthly profit was not withdrawn, he would add that amount or roll it over into their investment to reinvest. He told them that he was a licensed real estate broker as well as a licensed notary. He also told them that he planned to use the investment money to purchase, remodel, and sell homes. He assured them that their money was in real property, that it was safe and legal. Many of the investors in this case in particular were family members. Over the course of about a year and a half, the licensee accepted several $100,000 from investors who believed the licensee was investing their money in real estate ventures. The broker failed to make the monthly interest payments to the majority of the investors and also failed to refund the principal investments when they asked for those. So as you can imagine, eventually this caught up to him and complaints were filed with our agency. And for us, while we understand that this was an investment scheme, for lack of a better word, he did so while, using the trust that people had in his connection to the real estate world. The licensee acknowledged during an interview with one of my investigators that he never used any of the investment money for other purposes beyond paying interest to previous investors. So he never bought a single home. He never remodeled a single home. He never actually invested any of the money. And every time he had a new investor, he sort of paid previous investors with that money. So our solution to that was revocation of his professional real estate license. The licensee disagreed with the agency's proposed settlement, and he exercised his right to have a hearing, which is great. Due process is available to anyone going through this. He argued that this was not related to his real estate business, but unfortunately for him, the administrative law judge agreed with the agency that it was related to his professional real estate activity because he garnered the trust by meeting at his office, his real estate office, using his business cards, indicating that it would be invested in real estate properties. So an interesting twist on this, and I kind of mentioned this before when we were talking about civil penalties, his license was revoked, but we actually had a second follow-up case with this individual shortly after because he continued to do unlicensed activity while his license was not renewed or not active. So in addition to his license being revoked, he was issued a $600 civil penalty. That penalty would be even higher now for those who follow because actually the real estate industry led the way for legislation to increase the fees for unlicensed activity, but his unlicensed activity fell into a window at that lower amount that it used to be. So this is, I chose this case as an example, sort of back to back with the other case that I shared, one being a case where there was a criminal conviction, and this case, there were certainly civil matters filed for the money recovery aspect of these. But in both cases, there was an argument made that it wasn't related to real estate activity. And in one case, there were ways that a limited license might protect consumers and limit access. In this case, he absolutely tied it to his real estate activity. And he was, a license is only issued to an individual that can show competence and trustworthiness. And the commissioner can suspend or revoke a license for anyone who demonstrates a lack of those qualities within the licensed profession or related to their ability to conduct that licensed profession. I'm going to pause here just because I can't see the chat, Kelly. Are there any questions popping up? Okay. All right. So in this case, the agency received a complaint that a buyer put in an offer for a property owned by the respondent or licensee. So a complaint was filed, and we call the person that the complaint was filed against the respondent. In this case, they're a licensee selling their own property. The licensee as a principal to the transaction listed the property on MLS and failed to disclose within the public comments that they were a principal. Additionally, forms were not filled out correctly, and therefore there were repeated requests by the buyer's broker for there to be corrections made. While we don't regulate forms, and I want to say that very clearly for anyone listening, we do not regulate forms. There is a professional expectation. There is a standard within the industry. And in this case, this licensee was attempting to use both suites of forms sort of interchangeably, and like some of them in old versions. And so there were aspects about what was occurring where forms are mentioned, but I want to be clear, it wasn't because they used one set of forms or we regulate what's in the form. It's because the transaction couldn't continue because of the way that the broker was engaging in that. Additionally, there was a buyer repair addendum that specified the required repairs needed to be done by licensed contractors. However, the seller and licensee used a company whose contractor license had been expired since 2014. The licensee also indicated an electrician allegedly said some of the repairs requested did not need to be made, but refused to disclose the electrician's name. Then the licensee was asked to respond to engage with us on, who did the repairs with the electrician, and stated all repairs were completed by a licensed contractor, but would not include documentation and would not provide the name to us either. Finally, when we asked about documentation for disclosure, it was clear that that the listing agent did not include proper disclosure publicly. They did indicate in their listing that the listing agent is also the seller, but only in the private remarks section, and that does not satisfy the full scope of the law and expectation. In this case, the sanction was a reprimand. So the respondent stipulated to these findings or agreed to the findings and accepted the reprimand on their license. Ultimately, the takeaway that I think we want to repeat is, document, 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 but also disclose, disclose, disclose. We have a lot of cases where documentation and disclosure are central to the sanctions that licensees experience. Okay, let's see. I'm seeing, it's not, okay, there we go. It feels like it won't go to the next slide. Okay, so we have a couple cases here kind of towards the end of the presentation that are not examples that are real estate brokers or principal brokers, but Both the commissioner and I felt they were important lessons for the industry. And I'm going to preview some concerns that the agency has around property management that obviously principal brokers can engage in, that I just think we think it's a good idea to preview for you all. So let's start with the escrow case. In this case, the residential real estate sale agreement was signed in August 2023, but was later terminated. But then the same buyers came back and signed a second one. And in that second real estate sale agreement, they included language that said the earnest money to be non-refundable. The buyer's broker, once the transaction failed and escrow was trying to determine what to do, there were some emails that went back and forth, and the buyer's broker indicated that the agreement, which had already been signed by both sides, was supposed to say shall not be non-refundable. So a double negative was what it was supposed to say. But as I mentioned, they were signed by both parties with the language that it was non-refundable. The escrow company, who was actually the subject of our investigation in this case, returned the money to the buyer on July 18th. But unfortunately, because the real estate sale agreement said that it should have gone to the seller, we found that they operated outside of their duties and responsibilities and failed to execute per the real estate sale agreement. So they didn't follow the terms in the agreement for the distribution. There were also written instructions in the real estate agreement, an addendum that the licensee violated. And those are just sort of I listed the laws in case anybody's curious and wants to look up where you would find all that. And just all of that above demonstrates untrustworthiness or incompetence. Those are very difficult words to hear. I want you to know no one has ever seen that in a stipulated agreement and thought, I want to align myself with either of those words. But the reality is that in that moment, that's what happened. Either you were unable or you did not fully live within the trust given to you to execute something properly, and it resulted in a violation. In this case, the civil penalty was $3,000, which the escrow company agreed to pay. They were represented by an attorney, and the facts were pretty clear. One of the benefits of working in the industry that you all work in is a lot of what you do is in writing. Make sure that what's in writing is on your side of things. But while escrow is required to follow the terms in the sale agreement if it's signed by both parties, another takeaway here is imagine how the buyer's broker feels now that their buyers intended to have it say not be non-refundable. And this ended up actually not only being something that went through investigation, but was in civil court as well. So, a lot of back and forth. In this case, escrow was who was being investigated, but I would imagine, in a world where your reputation is a big part of how you get future clients, word of mouth and all of that, this certainly could have, or maybe has had a negative impact for those buyers who were given money, they thought that they were owed, and then really it was the seller who felt they were owed that based on the omission of a single word in the sale agreement. Any questions on that? I have my last case after this and then some time for questions, but yeah, Bill.
I have a quick question. Did the sellers get reimbursed the money that was supposed to go to them per the terms of the contract through civil litigation?
I don't know. It was pending when I was doing like we talked about before, sometimes the process is like through the association or civil court or criminal don't follow the same timeline. And so I don't know. I hope they
Gotcha.
did.
Yeah, I hope so too. It'd be an interesting outcome to understand
Yeah.
since they were effectively at fault.
Yes.
Thank you.
You're welcome. Okay. Oops, that was too many clicks. Okay. So this final case is property management, but as I indicated, there are some elements to this case that the commissioner and I felt were important, and I also want to share about this case before I tell it. That's how big the impact may be on your perception of how things currently work, that we're looking into legislation for the 2027 session based on what we've learned are gaps in our current law and rule. So please understand, as I go through this, it's a lot to unpack. So in this case, we had a property manager who failed a client's trust account audit in February of 2024, essentially could not reconcile their accounts, could not provide all the records needed. And because of the failure of that client's trust account audit, an investigation was opened. The first complaint-based case, meaning not opened by the real estate agency, but someone had a concern about this property management company, was filed that same year, but not until August. Eventually, we got 8 complaints. In this case, we ended up finding altered bank records that led us to subpoena the bank records directly from the bank so we could see what was actually occurring. That document alteration was identified by one of my investigators, and we moved forward with the subpoenas in this situation. We ended up discovering that there were bank accounts that were being used for property management that were not registered with the agency, which was required, that there were, falsified documents submitted to the agency, but also things like missing records and ledgers. This property manager wrote checks to herself. She wrote checks to family members. And thousands of dollars in big round numbers. So the agency did what we're supposed to do, and we issued a notice of intent to revoke the license. There's a lot of process that's involved in that, including like waiting periods and then the right to request a hearing and that sort of thing. But I think for the sake of time, the important thing to know is in that period of time, the original property manager was sort of working behind the scenes, as far as we understand, to get her sister licensed so her sister could take over the property management business. So, as you'll see in the timeline on the slide, the original property manager stipulated and agreed to the revocation of her license on March 31st. But her sister became licensed and was associated with the business on March 19th. So, essentially, the protection we tried to put in place by revoking her license was not as effective as we had hoped, because her sister became licensed and then immediately signed a delegation of authority allowing the revoked sister to perform all the duties and responsibilities, which you don't require a license for. So that's why I told you at the beginning of this that we're looking into legislation for the 2027 session around. Normally what happens is somebody delegates their authority to someone else and they're still, they're licensed, and they just maybe, want to hire an accountant, or they have an assistant that supports the process. In this case, the fact that you don't require a license to do some of these delegated tasks, they found a loophole, is what I'm saying. And so basically that person continued to run everything just under her sister's license. I also want to add that in this case, not only was it all within the family, within the sisters, but there were also concerns of elder exploitation, because some of the properties that they were managing were their father's properties, and some of those properties had liens put against them and money borrowed against them. And so we are mandatory reporters, and we do file with DHS to protect the elder community when we see elder exploitation. So let's see, there's so much to say in this case and so many details. That's the very boiled down version. But in this case, what we realized was not only did they find a loophole that we're surprised nobody else ever has, but we were really sort of powerless for a period of time to figure out what to do. So there were 18 complaints filed against the property management company against the second sister. And the second sister, really didn't have any background in property management, didn't get into property management because of a desire or passion to do property management. She was pursued by her sister as a plan, as part of a plan to continue to maintain this business and the income that it provided. And we don't do this very often when there are concerns. Typically, somebody can surrender their license, but not in lieu of the agency taking action because they've done something wrong. In this case, we accepted a surrender from the sister after she became fully aware of the seriousness of the nature, because we felt that she didn't fully understand what she was getting into in the first place. So, with surrenders, those are not published. They're not in the ORNJ. And so if you were to, look at the orders published on our website, you will not find the second person that's part of this story, because we really felt like they were being used in a way that they didn't fully understand.
Ellie, it's Tang up in Portland, Dave Tangvald. I just wanted to encourage that you said there was 100 participants roughly in here, and that's so awesome to see the engagement with the agency. I just want to say that from a licensee's perspective. It is your transparency in this class, and as you practice, your daily routine is respected by each of us out here and authoritative. But I also want to put a human touch on that, as I've had a complaint against me in the agency, and my response is to my response, and then I would journey that down to the agency so that I could feel what was happening to me, and then go in and have my side and turn it into the investigator. So I think that this is a great key, if you will, to the agency on the investigation side, because it does take some communication and things like that. I have had a letter of education issued to me and to my license before in the past, and I learned something from that that I could share with others. And so I'm transparent with my experiences with the agency, just so that other licensees can see that it's, making a mistake is one thing, being responsible for it is another. And when we're licensed in the state of Oregon, we are held to a higher standard. And I'm probably held to a higher standard than some of the other licensees in the room just because of my background. And I just think it's important that we realize that you are people and we are people, and that our license is what we treasure. And communication and taking notes, which I have right here, is key. So thank you so much.
Yeah, thank you.